All right, here we go. For the few of you here in court, we have a jury deliberating right now down in Judge Glanville's courtroom. They will take priority. So if I get word from Deputy Gordon that something needs to happen, we'll need to pause. I think we'll be through with what we need to do pretty quickly, and it's not going to impact you all. It may be the afternoon calendar that is more impacted. I brought them some donuts, and there were only 5 people there when I handed those off. So maybe more have shown up, Deputy, but you need to make sure they aren't deliberating till we get all 12. Okay. All right. Good morning to everyone who's on the call. Hopefully you can hear us here in the courtroom. The first position I have is Tyler Thomas, and I believe that may be the gentleman who's at Georgia State Prison, but I'm not sure. Is that you, Mr. Thomas?
Yes, sir. Yes, sir.
Hey, good morning. I'm Judge McBurney. We have never met, but your case is on my docket now because I have inherited Judge Downs's docket, and she presided over your trial. I did a little homework last night to learn a little bit more about your situation. You had a trial. You were represented by Mr. Garland and Ms. Clark Palmer. Trial didn't go so well for you. Then you hired Mr. Weintraub, who is here in court. You can't see him right now, but you'll get to see him when he is talking about your case. He and a colleague handled your motion for a new trial. That went better for you. Judge Downs ruled what she ruled. It went up on appeal, and the Supreme Court concluded 2 things. One, that granting you a new trial was affirmed. But 2, there was sufficient evidence to support the jury's verdict that you could be tried again. So it was a big win for you, but not the total win that Mr. Weintraub was arguing for. If the Supreme Court had found that there was not sufficient evidence, then the state would not be able to try you again for the murder, I think it was of a Mr. Brown, in a drug deal that allegedly turned into an armed robbery. Mr. Brown got shot a bunch of times in his own car from whoever was sitting in the backseat. So what I'm going to do first is ask whether it's Mr. Abate, whose name featured prominently in much of what I read about the case, or Ms. Convery, what the state intends to do next with Mr. Thomas. Then I'll hear from Mr. Weintraub, who may be saying Mr. Thomas needs to find a trial attorney. But if the state's done, then we're done. But the state, that may not be the perspective. If you don't mind coming to any one of the microphones, it's important that Mr. Thomas hear you, not just me. If you're going to sit at council table, if you just turn that microphone on, please. Well, if you make the little green light go on. There we go.
To answer your question, Your Honor, the state would be moving forward with another trial.
Okay. So, Mr. Thomas, the state intends to retry you. Mr. Weintraub, will you be remaining as Mr. Thomas's lawyer, or should we go through the process of getting him, or should he go through the process of getting a lawyer? If you go to a podium, that would be great. Thank you.
I had the pleasure and privilege of working the case with Elizabeth Brandenburg. And
hey, Ms. Brandenburg, I saw her name on all the pleadings as well. I just wasn't sure if that was Ms. Brandenburg.
She argued the case in front of the Supreme Court. We're going to be filing our entries this week. We will continue on in the case.
Okay.
I will want to put the court on notice that so nothing is waived. There's a strong possibility that Mr. Abadi will be called as a witness. So his capability of handling the case and being a witness certainly poses an issue that we'll have to address at the appropriate time.
Sure. Well, I'm sure that the district attorney's office is aware of that possibility. Just
Yes,
in
sir.
reading the motion for new trial, the order on the motion for new trial, and then I think it was Justice Naimi, whoever, the Supreme Court opinion on the case. I appreciate that dynamic might arise. we would cross that bridge well before a trial
Yes, sir.
and see how the state wanted to manage that. Do you know, Mr. Weintraub, if Mr. Thomas is in state custody for any reason other than this case?
It's my understanding it's only this case, Your Honor. We have filed a motion several weeks ago for a bond pending the scheduling of the trial during the pendency of the trial. I'd like that to be heard at some time, Your Honor.
There's something going on with the sound.
Yeah, there is. What I'm going to do, it's not at our end. It's at Mr. Thomas's end. So I'm going to mute that one, and that should. It now no longer sounds like anyone is raking gravel. So, Mr. Weintraub, you were explaining that you believe Mr. Thomas is only in state custody because of the murder conviction, and so that means he needs to be brought back to Rice Street, and then we could have a hearing on your request for bond.
Yes, sir.
Once he's back here and the state has a chance to prepare for that.
Yes, sir.
Okay. So, Mr. Thomas, next steps for you is that my office will confer with the Department of Corrections, who are the folks who were good enough to set up this Zoom link with the Georgia State Prison. And if we confirm that there's no other basis for you to be in state custody, then we'll do a production order to get you brought back to the county jail. When that happens, assuming that's the right next step, then we can get you on a calendar to have a discussion about bond. And just so you can, I try to make it clear, but basically where you are procedurally is everyone needs to get ready for trial, and they're going to try your murder trial again. So we got to get you back into Fulton County because that's where the case would need to be tried. I'll work through whether you wait in jail or not in jail for your trial. We are doing jury trials again, so this is not something where we're going to need to wait for years and years. This will almost automatically become my oldest case when you get back here. And so it will move towards the top of the list. That said, I will certainly give Mr. Weintraub and your defense team the time they need to get ready. So it's not that there'll be this mad dash to a trial next month, but it will be a case where I will be pushing the state and the defense to say, what's a reasonable date to set this down for trial? It's not going to get any easier for anyone to find the witnesses in this case the longer we wait. Mr. Abate, anything else from the state on this case?
Nothing further from the state, Judge.
All right, thank you for being here. Mr. Weintraub, my team will work through whether Mr. Thomas can come back here or not. It sounds like he should be back here because the only reason he's in state custody is the murder conviction, which isn't anymore. And once he makes landfall, then you can reach out to Ms. Nelson to figure out when we should get into court to do whatever's next.
It'll be Ms. Brandenburg, myself, Mr. Alper. Ben Alper will be representing Mr. Thomas.
Big team. All right. Well, any one of you is free to reach out to Ms. Nelson just to let her know Mr. Thomas is back and we'd like to get on a calendar for whatever it is we need to talk about, whether it's bond or pretrial things, but we'll take care of that.
Yes, sir.
Okay. Thanks, everyone. Mr. Thomas, do you have any questions? You're on mute right now, so someone would need to unmute you, but I want to make sure if you've got any questions about what's going on, we can address that right now. See someone reaching out. We need you to unmute at the Georgia State Prison end of things, please. Mr. Thomas knows what needs to happen. Big smile. Ms. Beasley, do you have any thought about what we can do? Good morning. You're in a tough spot. It says your bandwidth is low.
Yes, Judge, I'm so sorry. I'm working on many courts at one time. If you give me a second, Judge, I'll get GSP to unmute.
Thank you so much. Ms.
Sorry
Beasley,
about that, Judge.
no problem. She has to manage the connections for a bunch of the metro courts.
Better. Georgia State Prison. Georgia State Prison, can you please unmute?
Trying, they've got like 18 devices. There we go. Excellent. So, Mr. Thomas, you were able to hear everything we were talking about. Do you have any questions?
No, sir.
Do you know of any other reason why you are in the Department of Corrections custody besides the murder case?
No, sir. I don't have any pending charges or no holds. No, sir.
Okay. Then you'll probably be coming back to the Fulton County Jail soon. We'll see you then. Thank you. All right. Thank you, Georgia State. Thank you, Ms. Beasley.
Thank you, Judge.
You have a good day, Your Honor, and good Father's Day.
All right. You too, Ms. Brandenburg. Nice to meet you. You guys are done. Thanks. Next up is Mr. Bivens. What? Oh my gosh. So we have a probation warrant from May of 2020.
So I think it's on the calendar for the 2005 case that was administratively dead docketed and I guess never resolved.
Oh, yeah, but this probation warrants for the 2012 case.
Correct. So
Okay.
I think there must be two reasons holding him in custody. It's my best guess.
Okay.
The old case and then the revocation.
Are you working with Mr. Bivens right now?
I will be. I haven't met him yet, but
Okay.
per numerical assignment, he should be my case.
All
Unless he's
right.
hired.
So, Sergeant Clemson, how are we today connecting with folks? Are they going to courtroom 3? Was this supposed to be the booths? Because I don't have any booths on my screen.
It was not set up as the booth, Judge.
Okay. Thank you. I wonder how we're going to see the defendants. Collecting. So they're all here? Good. Collection time. Pardon me? Yeah, if all 12 are there, once they don't have their electronic devices, they should get back at it. Mr. Adams, you are with us. That's good. Johnny Avery, we took care of. And then we're taking one plea for Judge Ellerby. Are the lawyers for Judge Ellerby's case on the call?
Your Honor, good morning. Adam Petty. I am representing the defendant, Mr. Oddister. Mr. Trepanier is down, I believe, in Judge Ellerby right now. I think he's doing a bond, if I'm not mistaken, over there. So he's asking that we take that matter up last.
Sure. That's fine. We can take up, sadly, no matters right now, but once the jail lets us know what's going on, can you give me the name of your client again?
Yes, sir. It's Raymond Odister, O-D as in David, I-S-T-E-R. On the indictment, it's Obister, O-B as in Brian, but it's actually Odister.
So Judge Ellaby gave me some background on Mr. Odister. I know you don't control all these things, Mr. Petty, but is it your sense that your client, Mr. Odister, is prepared to accept the 3 years to serve 2, or we'll see which Odister shows up today?
My understanding, Judge, as it currently stands, is he's prepared to take the 3 serve 2 balance probated. I do need to speak to him just to go over Boykin and everything like that for a few moments. I'm not going to have a moment, but presuming everything is what it was the last time we talked, we should be good to go.
Got it. Great. I promise not to ask him his date of birth. That should help. So.
Yeah, I make no promises, Judge.
Yeah. All right. Great.
Thank you.
Ms. Nelson, do you have a point of contact in the sheriff's office who might be able to let us know what's happening at the jail?
Okay, I'll reach out to them and see what's going on.
Thank you so much. Mr. Franklin, Bonventura can't be put on the July calendar. I forgot I have a conflict that week, so it will be August at the earliest, and I'll just need to make sure I am not putting too many of your cases. I know you had flagged some that were able to go on after you had enough time, August or September. So as long as we're not overstacking one of the calendars, Bonventura, it wouldn't be till August, July.
I think that probably works better for Mr. Rao. So I'm sure you'll let him know, but I'll let him know.
Yeah,
as
well,
well.
I remembered, because I wasn't sure if you guys were going to dial in for the pretrial conference based on our conversation yesterday. There's no need to.
I was gonna show up either way because I have the second one. Yeah,
but the answer is Bonventura will need to be in August. And so because you will bear the brunt of it on the defense side, if the hiring powers that be do what they have said they're willing to do, we will be adding some folks to our jury services team and changing some things with jury selection such that by the end of August, ideally, it'd probably be a little later than that, we'll have our own trial calendars. So it won't be this concatenation of a bunch of different ones. It'll just be McBurney cases, which will be Franklin cases mostly. Right. That means we can put bond cases on there, et cetera. In fact, we're going to be able to put bond cases on some of these consolidated calendars, I think starting in July. So real old bond cases that are ready that people want to do, because we keep running the calendars. Then we don't use the jurors. We put as many jail cases as we can get people to put on them, and they all go away. They're continued, they plead, they're dismissed, and then the jurors don't get used. And so the thinking is, well, then why not start doing some of the old bond ones? Because if we can't convince judges or lawyers to get the jail ones on a calendar, let's not waste the calendar. So there'll be a few cycles where we can add bond cases, and then ultimately, ideally by the end of August, early September, there'll be up to 8 jury selections a week down in 1D and 1C. The trials will be here in this court, well, in each judge's own courtroom, but jury selection will be in 1C or 1D. And then you move on up here to try the case. But we'll be doing enough that it makes sense to say, Tuesday is going to be McBurney in 1C and Dunaway in 1D. And then we wouldn't be up again for a spin of the cycle, but that'll be our calendar. It'll make it a lot easier to get input from you and Ms. Patel.
So it's just McBurney cases, and then we'll kind of be able to figure out of these 10 McBurney cases, then
exactly
these are the 3 that we're probably looking at trying. Or
correct. Okay. It'll be how it was supposed to be, where Ms. Nelson will publish the calendar, but we would meet in advance and say, here's what's on the calendar. What makes the most sense to?
So could I ask this question as well? Because I've heard whispers of them restarting like a backlog division and maybe cases being reassigned. I don't know if that's true or not, or
So backlog is a controversial term for some judges. It's the right way to describe it because it's relating to folks unindicted or indicted that need to get tried. It's the byproduct of the pandemic as opposed to some of the historical bases for backlogs. But there is an effort being made to staff up. Hey, Ms. Ellison, how are you? Good morning. To staff up to create a way to address if this wave of new indictments comes through of sort of the pent up demand of getting cases indicted. I don't know that it would work like the old backlog where, each division could say, here's 5 cases that I'd love to not have to deal with anymore. And then in a few divisions, here's 50 cases that I don't have to deal with anymore. I don't think it'll work quite like that. I think it might be more of as cases come through new indictments, there's sort of a triage, but that's all being developed. And whatever the model is, it will be different from what you may have experienced in the past where Judge Baxter sits astride this list of 100 cases, all of which is 4 years old, all of which are 4 years old or more, because we've learned it doesn't work. The lawyers can't follow them because you need to be here and you can't be in Baxter as well, which is why if it's a new case and there are new public defenders added, new ADAs added, they can own the case and the client from the beginning. So, but the answer is TBD.
Okay.
What I do know is happening is that we will be pushing cases and calendars back to divisions rather than having a consolidated calendar, assuming, and the only hurdle, because we got the clearance from the Board of Health, the only hurdle is getting enough jury services people that they could support managing 2 sets of jurors Monday through Thursday down in the first floor.
well, with that being said as well, I do have a bit of other news for you.
Uh-oh.
Yeah. But I will tell you that so there's shuffling and reassignment, and I've been designated, but I will still be keeping some of my older cases because I've had them forever.
Yeah, and that's, you can't rebuild. I mean, it takes so long to rebuild.
Yeah, so certainly Goolsby and Buvinger, whenever those need to get tried, I will still be there for that. I think Jerry Hodges is another. Daryl Lowe.
So will you at least be in a courtroom or are you being moved to some supervisory?
No, I'll be with Judge Leffridge.
Okay.
So we had actually my former partner, Ms. Northcross, she was with Judge Leffridge and she's leaving.
Oh.
She's going to another firm.
So they need a senior
Yeah.
in there. What will happen here?
Ms. Patel will fill the vacancy of the senior spot, and there'll be a non-complex attorney brought in. And I think that Ms. Patel it will be the kind of split where she'll just have the majority of the more serious cases. But I told Ms. Hall about it, the potential of it a couple of days. It just got confirmed like yesterday. A lot of the less serious cases that we have together, she was kind enough to kind of put some extra hours in on the weekend to give me some more direct offers. So I think we'll be able to, the ones that quote unquote need to work out.
Yeah.
So we got some that'll be reduced or dismissed or something. So
has Ms. Patel tried a bunch of cases? I mean, we have this weird 18 months where no one could try anything. I just don't know how long she'd been here.
I know she has a few.
Okay.
Yeah. I'm not sure like dozens or nothing like that, but yeah, she certainly tried some.
Okay.
And she's definitely sat second chair on a bunch. So
okay. That's a big caseload you're moving into.
I wasn't sure. I tend to find myself in those.
You did great here with what Judge Reeder picked up and all the stuff that got shifted over from Bedford and Campbell. So I've dealt with it before.
I also spoke with Miss Ms. McCauley, and she's given me some competitive offers on some of the older CWAC cases. Where we're both just having conversations with the clients about.
When does the transition happen?
The new attorney will be here July 6th.
Okay.
But again, I'm kind of a glutton for punishment. The people I have relationships with, I hate.
Well, but I mean,
I did it for myself with Dunaway when I left his courtroom too. I kept a couple and tried a couple. So I'll kind of be in the courtroom and a half.
Yeah. Well, Judge Lethbridge and I get along fine. We're literally next door neighbors, so I'm sure we can try to minimize the impact on her process flow and your quality of life by trying to schedule those trials in a thoughtful way.
Yeah.
It's too bad that things happen the way they did, because Bonaventura we could have taken care of next week and that would not have been hanging on. But I understand what happened.
Yeah.
Ms. Nelson, any update from our friends at the jail? Oh, courtroom 3 is there.
Yes.
How long have they been there? We could have started. I'm sorry. I didn't.
Before y'all start talking about Devin's transfer.
Oh.
I didn't want him to leave, so I tried to interrupt.
Yeah, okay. All right. I wish you had veto power, Ms. Hall, but that's not how it works. Okay. Is that Mr. Bivens? I'm not sure who's in courtroom 3.
Yes.
Hey, Mr. Bivens, I'm Judge McBurney. I'm sorry we left you sitting there. We're just trying to figure out what the plan was. So, Mr. Bivens, you have a real old case from 2005 that we need to talk a little bit about, and then a medium old case from 2012. The 2012 case, you got I guess a fairly long sentence, at least part of it on probation. And a judge in May of last year, about a year ago, signed a probation warrant, because it was alleged that you had gotten into some trouble in Clayton County around Thanksgiving of several years ago. So one issue we have to talk about today, I don't know, we'll resolve it today, is your probation warrant. And then we need to talk a little bit about your case from 2005, where you were charged with having some marijuana, and it was administratively dead docketed in 2006. But that doesn't mean that it's closed out. It's sort of like putting it in a freezer, and we're taking it out of the freezer now to say, hey, here's Mr. Bivens, and here's this case, and we need to figure out what we're going to do with it. Ms. Hall, have you put together any plan for either the 05 or the 12 case, or are you waiting to figure out who is speaking for Mr. Bivens, or where's the state on these?
I've talked to Mr. Franklin a little about the cases. I ordered the 05 cases in our archives. I have not received that yet. Of course, I ordered it to get the discovery out in case Mr. Franklin needed it, but also to see if we've already completed our drug lab on the marijuana.
Okay. And then the 2012 case, it's a revocation piece. So it may be that we try to sort it out in conjunction with the 05. I'm seeing if Odyssey will even tell me anything about the 05 case. It's only a 5-digit indictment. You know, the case is reinstated because Mr. Bivens made it into custody. Well, all I've got is the dead docket order and the reinstatement. Okay. Well, Mr. Franklin, what makes the most sense from your perspective? I guess you need to get some paperwork and maybe get a chance to speak with Mr. Bivens.
Yes, sir. And so I'll let you in on kind of where I was going. So I was asking Ms. Hall initially just kind of, what were the state's intentions with the 2005 case? And we realized that he at least had some contact with Fulton County in 2012 because he had a whole case here and evidently resolved that case. to me, that would alleviate any concerns about any delay for the 05 case being attributable to Mr. Bivens. I think it's certainly an argument for a constitutional speedy that would then come into play at that point in time. So I then asked Ms. Hall, well, let's just take the easiest route, right? It's a 2005 case for marijuana. What's the chances that they still have the marijuana or that it was actually tested? So she was looking into that. So I'm hoping, very much hoping that the 2005 case will be addressed. But Ms. Hall certainly has some work to do in looking into that. And I need to, of course, speak to Mr. Bivens about the resolution to the Clayton County case.
Okay.
Because I would imagine that he may have some time from that may be useful in us resolving the notification. So I would ask for a reset 1 week longer than what Ms. Hall would anticipate the discovery coming in. Right. I don't think it'll take a Herculean effort.
No, my guess is it'll be a thin file. Ms. Crawford, good morning.
Good morning, Judge McBurney.
How are you doing today?
I'm okay. How are you?
I'm well. Ms. Crawford, how much time remains on Mr. Bivens's 2012 case?
Mr. Bivens has 6 months and 28 days remaining.
Okay. Well, my hope is when we get the case file for the 05, we're able to probably wrap all of this up and see where we can go from there. Mr. Bivens, were you able to hear what Mr. Franklin was saying while we were talking about your cases?
No, sir.
No, you couldn't hear him, or no, you didn't understand exactly what he meant?
I didn't really understand.
Okay, so here's what we're going to do. You have an open case. You were charged in 2005 along with one other person named, I closed this one out, someone named Jermaine Facey. The two of you were charged with having marijuana. That's still an open case, even though it's from 16 years ago. It's an open case. The state is going to get that case file and get that paperwork to your lawyer so he can look at it and talk to you about it. That's problem number one you have. Problem number two you have is that you had a case in 2012 for attempted burglary and entering a vehicle, things like that, that you pled guilty to. And you got sentenced to 6 months in jail, followed by 9.5 years of probation. And about a year ago, someone signed a warrant for you because you did something you may have done something that violated that probation. It's alleged that you got in trouble in Clayton County.
So by that being said, like my probation was 9 years, 6 months, and I completed 9 years, 6 months on probation. If you add up the time.
Well, almost. That's what I asked. You may have heard and seen Ms. Crawford on our discussion. She's with probation, and she tells me and you that you have just under 7 months left of probation. She said, as of today, you've got 6 months and 28 days. So one thing Mr. Franklin can look at is maybe that someone's not doing their math right. But according to probation, you got about 6 months left before you're done with that. Basically, Mr. Franklin, your lawyer, needs a chance to look at this paperwork and, more importantly, talk to you about it so you and he can figure out what makes the most sense to do in this situation. So I'm going to give him a chance to get that paperwork from the prosecutor, get out there to talk with you, and then we'll get everyone back together, whether you come over here in person or we get you hooked up just like we are right now to figure out how we're going to resolve this. It should not be very complicated to resolve it, okay?
I'll be at the jail this afternoon or this evening, Mr. Bivens, and give you an update.
I got it. So I've been in jail 28 days, sir. And,
say that again?
I've been in Fulton County 28 days and nobody haven't came to see me, and I'm just trying to really get back to my family because I have bills to pay, sir. I've been
Okay,
locked up.
so I'm sorry you've been there that long. I didn't have the count quite that high, but we're moving this case as fast as we can. You got on our calendar pretty darn quickly.
Can I interrupt, Judge?
Pardon?
Can I interrupt, please?
Yeah.
I'm communicating with Ms. Hall right now. If we could have like 5 minutes to hop off and have a conversation,
Yeah.
I may be able to
Resolve this.
yeah.
Okay.
So if we could.
So here's what we're going to do, Mr. Bivens. The prosecutor in this case really wants to talk to your lawyer. We may be able to sort this out today. So I'm going to ask the deputies there just to put you to the side, and we're going to get you back on this call after the lawyers can talk to see if there's something we can sort out today, like you're asking about. Okay?
Yes, sir.
All right. So if we could have Mr. Wade, but please don't take Mr. Bivens back to his cell.
And just to confirm, Ms. Crawford, you said it was about 6 months remaining, correct?
6 months, 28 days.
Okay.
That's correct. 6 months and 28 days.
Mr. Wade? Mr. Adams, are you on still?
I am, Your Honor. Thank you. Good to see you.
Good to see you. So we had Mr. Wade on a calendar a few weeks ago. And at that time, there was a discussion as to whether you would end up being his attorney of record or if it was going to be someone else. I'm checking the docket right now to see if that entry was filed. We still don't have an entry of appearance. Are you going to be handling this case for Mr. Wade?
Yes, sir. It's filed 13, Your Honor.
Can you say that again? It's kind of hard to hear you with what's going on in courtroom 3.
I say an entry of appearance was filed on the 13th. Now, that was filed on the CP case, so I'm not sure if it's filed on this, but I will be representing them. Yes, Your Honor.
Okay, you file an entry on the case that may be the basis for the revocation.
That is correct.
Got it. Okay. And I've got the petition here. So tell me then, since I am now talking to the correct lawyer, Mr. Adams, thank you for being here. What is your plan? Do you want there to be, when we've got a petition like this, the allegations are that Mr. Wade committed another aggravated assault. He is on probation for aggravated assault and possession of a firearm by a convicted felon. And the allegation is that a few months ago, it happened all over again. So pretty serious situation. Do you want there to be a revocation hearing where the state calls in witnesses to prove it up? Or do you want to wait to see what happens with this CP case? In other words, is it indicted and then this revocation just follows the indictment?
I think it'd be best to do it that way, Your Honor.
All right. Ms. Hall, Ms. Hall, do you have any objection to holding off on the revocation for now to see what happens with the unindicted charges?
No, Your Honor, I have no objections.
Okay. Mr. Wade, do you understand what we just talked about?
A little bit. I couldn't hear what my lawyer said.
It's kind of hard to hear because there's a lot of background noise where you are. Not your fault. But here's what we discussed. you have a couple options here, and your lawyer makes the call. It's his professional judgment. One option is basically a mini trial where the standard of proof is much more favorable for the state on these new charges. And that would be in front of me. And if I found that the state had shown by a preponderance that you did whatever it is, your charge that you did in February of this month, then I could revoke your probation. The other option is to sit tight for a little bit to see when the state's going to indict you for the new charges. And then we don't worry about the probation right away. We see what's going to happen with your new charges. And Mr. Adams, your lawyer, has indicated that he thinks it is wiser for you to not have this mini trial in front of me where the state doesn't have to prove things beyond a reasonable doubt, and instead wait to see what the indictment ends up looking like and try to resolve it then. Did that make a little more sense, or were you able to hear that better?
Yes, sir.
Okay, so you and Mr. Adams should keep talking. Mr. Adams, if at any point you and Mr. Wade have a change of heart, let Ms. Nelson know. We'll put this on a calendar a little ways out so no one forgets about it, but we can have it occur sooner if you and Mr. Wade decide, you know what, we'd rather have that revocation hearing instead of waiting on the indictment. Okay?
Okay, Your Honor, just for the record, he does have a court date on the 21st for purpose of bond, just.
For the unindicted charges?
Yes, Your Honor.
Okay, got it. Well, if that changes things, let Ms. Nelson know and we'll get back together, okay?
Okay, thank you so much, Your Honor.
You bet. Thank you. So did you still need to talk with Ms. Hall?
We have an understanding. I think it'll be okay with Mr. Bivens. I just need to communicate that to him.
Okay. Do you need to speak with him privately, or can we just bring him in the courtroom? What's better?
I think we can bring him into the courtroom and
Okay.
I can announce what our intentions are.
Great. Can we get Mr. Bivens back, please?
Yeah, Judge.
Thank you. Oh, there's Obister. Do we have Trepanier? Mr. Petty, any update on Mr. Trepanier? I thought that Judge Ellerby had a bench trial right now, and so I thought that her lawyers were free.
That's my understanding too, Judge. I'll send Mr. Trepanier a quick text, see if he can give me a status.
Great, thank you.
Sure, Judge.
I've talked with his case manager and they said as soon as we need him to notify him. So when you're ready, Judge, I will send her a message.
Okay, great. All right, we'll do that. We're not quite ready. We need to work through Mr. Bivens. Mr. Bivens, welcome back. As promised, your lawyer spoke with the prosecutor. I'm going to let your lawyer, Mr. Franklin, give us an update of how this situation might be resolved. Are you able to hear us?
Yes, sir.
Okay.
So, Your Honor, I had, and Mr. Bivens, I had a conversation with Ms. Hall. You can see her on the screen as well. She's the prosecutor handling the case. The state is willing to nullify or dismiss the 2005 marijuana with intent charge. In light of also recognizing that he's been in custody at least 28 days, the state is willing to revoke his probation for 28 days that he's already served. And given that there's such a short time remaining on such an old probation case, terminate the balance. So essentially it would close out both his revocation and his old indictment, and he'd be released from filtering on those two cases.
Okay.
But I'm not aware of him being held on anything else. So this essentially would close out all the matters and allow him to go home if Mr. Bivens okay with that.
Yes, sir. Yes,
Okay.
sir, ma'am. I appreciate it.
So the only thing I would ask, Your Honor, just in light of the fact that we haven't actually discussed one-on-one the nature of what may or may not have occurred in Clayton County, we'll ask just to not contest the revocation details as opposed to admitting to them.
That makes sense. Let me ask this, Mr. Bivens, when we've been talking about how you got arrested in Clayton County. It looks like it was back in November of 2019 for a theft charge and a trespass charge. Do you know, have those already been resolved? Is that an open case? What do you remember about that case?
They haven't been resolved. When I went to court, they reset the court date.
Okay, so you still have business to take care of down in Clayton?
Yes, sir.
Okay. Understood. Ms. Hall, was anything you wanted to add to Mr. Franklin's description of how this might work out?
No, Your Honor. And I already sent the email for the no process.
Okay. So, Mr. Bivens, at the state's motion, I will dismiss your case from 2005. So that's gone. And what Mr. Franklin is telling me is that you are not contesting the allegations of the warrant. And as a result of that, I will revoke 28 days of your probation, and you'll get credit for the time that you've been in. And I will suspend the balance of your probation so that when you are released, you will no longer be on probation for that case from 2012. Now, I don't know if you've got other cases out there. You clearly have something going on in Clayton. This doesn't change any of that stuff. So don't miss any court dates in Clayton. Okay. And if you're on probation for something else, you need to keep dealing with that. But for the case from Fulton County in 2012, that one is closed out once you are released. Okay?
Thank you, sir.
Ms. Crawford, do you need anything else from Mr. Franklin or Mr. Bivens?
No, Judge, I just need to know the credit from date.
Well, the jail will, it's whenever he got arrested. So we'll just say 28 days.
Okay.
All right.
Would there be a credit date listed on the calendar?
Well, the calendar says he's been in jail for 4 days. And we know it's more than that. So,
right.
Unless he got arrested in a foreign jurisdiction, it would just be his bookend date.
I know that sometimes Ms. Nelson will put the arrested date, and since it's since she published the calendar,
they're looking
how many days ago?
Yep.
Yeah, so I didn't list it this time. Okay.
He's been in 25 days. He was booked in 5/23/2021.
23 May 21. Okay. All right. So credit from May 23rd, 2021.
Thank you.
All right. Thanks everyone for Mr. Bivens. I think that gets us to Mr. Odister, who is hopefully down in courtroom 3.
One more interruption.
Sure.
So we said 28 days and it's been 25 instead. Could we amend Ms. Hall to revoke for 25 since the intent, I guess, was to go ahead and get them out?
That's fine with me. It's fine with the court.
Okay, 25 days unless Ms. Crawford has already printed out the order. 25 days will be the revocation.
Thank you.
Sure. All right, so let's get Mr. Trepanier on the call. How are our jurors doing? They're good?
He may be coming down, but just a minute, Judge, let me check with him.
He's right next door. He's welcome to come on in.
And Your Honor, I just shot Mr. Trepanier a text message. Do you think it'd be a good time if I can get with Mr. Odister now?
It would. We need to get him in to courtroom 3, and then I can move the two of you into a breakout room.
Perfect. Thank you, Your Honor.
Sure.
Judge, right here, I have Avery. This is Avery.
Oh, okay. I'll let Avery know what's going on. Hey, Mr. Avery, your lawyer has filed an entry of appearance, and her name is Ms. Bernard, and she has waived arraignment for you. So we're moving your case along. Today was just a chance to work through, did you want to be formally arraigned or not? But Ms. Bernard waived arraignment for you. So she'll be in touch with you as to, are we going to work this case out? Is there going to be a bond hearing? But that's a conversation for the two of you to have. And once she, your lawyer, lets us know what's going on, we'll get you back in court, okay? Great. Thanks.
Judge, Mr. Avery's case was my only case on the calendar. May I be excused?
Yes, sir. Thanks for being here.
Thank you, Judge. I appreciate it.
And Your Honor, that concludes my business. And when Mr. Trepanier comes, may I be excused?
Yes, ma'am.
Okay.
So how many different courtrooms have you cycled through? Dunaway, I mean, Reeder and McBurney will count as the same. Downs.
Aside from, so this is actually only like my third docket.
That's some good stability.
Yeah, so, but you know,
Judge,
Yes.
I only have three defendants on my calendar.
So there was a calendar for Judge Ellerby that I am told her staff reached out to the jail about. I can give you the booking number, but I'm filling in for her. It was a gentleman who was going to enter a plea. So you're right. If you're looking at my calendar, we're done. You guys hit a home run. You got everyone in there. But Judge Ellerby told me that her staff had arranged to have a gentleman come in and take a plea, and I was going to handle that for her. That's all I know.
Can I have the booking number?
Sure, it's 2007765.
Okay.
Appreciate it. Sorry for the surprise. I was told that you guys got notice.
Deputy, he's in cell 5N109.
How long were you in Dunaway?
about 2 years, I think.
Were you there when he started?
So since getting out of the complex, I went to Standard when Standard was a thing. I was there maybe after Standard started.
It may have been before I was here. Okay.
I was with Judge Downs, and then when they expanded Standard, I went to Judge Shue. They ended Standard, I stayed with Judge Shue. Judge Shue went to family. I think Judge Wright came at that point. She came back to.
Oh, so same docket fees, different judges, but same clients. Got it.
Shue, Wright, Tucson. Shue came back to the same docket, I think. She retired, Dunaway.
Were you
Downs right before she retired.
Were you the defense attorney in any of the cases where Shube over objection and over reversal would tell the jurors what the penalties were?
I was second chair on 2 of them, one of which I tried with the lady who I'm replacing at Judge Lethbridge.
Oh, so Ms. Norcross.
So I was there for that. And I think on a couple of my cases, she at least made the threat of informing the jury on certain things. She came very close to informing everyone of the sentencing on a murder case. And she stopped just shy of that, but we ended up getting not guilty on it anyway. It was one that shouldn't have been tried. It was her case was state.
That would have been interesting.
Judge,
Sir.
give me 10 minutes. You're gonna be on the way.
I appreciate it. We will sit tight. When he gets here, his name's Odister. When he gets to courtroom 3, I'm going to put him and his lawyer in a breakout room for about 5 minutes, just so that his lawyer can get him oriented. Okay.
Okay, that's fine.
Great. We will sit tight. I appreciate you doing this extra one.
No problem.
I still owe Miss Nelson a
cake.
I still owe Mr. Nelson a motion regarding Mr. Lowe, just to make sure everything is we're trying to make sure there's no formal gaps in how things are supposed to go.
Is Mr. Lowe someone who's been evaluated? I'm not remembering.
This is the guy he was incompetent for like 10 years and brought back.
Okay.
That kind of stuff. So I'm reaching back out to Georgia Regional to make sure we have a more recent, updated evaluation.
What's he charged with? Okay, so it's not going away.
Yeah, so this is we've been back and forth with the state about whether they would allow a NGRI or they're kind of hold on to he can plead to guilty but ill. And for us, it was basically a difference where this is Dave's. He has a prior homicide from another place, and my argument is that this is the second one. Nobody's gonna let him back out.
Right.
So NGRI is not the scary thing that I think.
Right. So you're keeping that, and then
I'll keep that because it's bounced around so many people in our office.
we would lose the institutional knowledge.
That and Mr. Lowe is comfortable with me.
Good.
And the only attorney he had Screen at some point in time. Then Ms. Walsh had the case, but she's got bigger things on the plate now. So
She does.
yeah, I don't want to leave him or throw that burden on somebody else.
So Lowe, Goolsby,
Hodge was probably the one that's the next.
and Bonventura. Okay, and Hodge. Let me just find, just since we're talking about it, and I know you can leave, but just give me a sec. From
probably run down Michael Tubman, but Mr. Tubman wasn't comfortable with trial, so I filed on continuances. That's the oldest CWAC case that I have. Equavian Rogers.
some of them, I guess like that, those we just didn't spend a lot of time. How do I rotate this? Oh, come on. There we go. So Lowe is our second oldest.
Just a second.
Yeah, well, there's an Antonio Taylor who is the same scenario as Mr. Lowe, but I think it's a robbery that we may need to, well, not yours. Hinton is not yours. That's a private attorney. Melvin Lee Henderson. That's not yours. It's a murder.
It's a big culture thing.
18 SC. No, but I don't think it's yours. Andre Griffin, Gregory Oliver. I think Gregory Oliver may be Ms. Patel's oldest. Dewan Cannon. There's Bonventura. So that's Goolsby. Harrison Trim. And he apparently has another case. He's got this real old one, but you have said before, look, it's not so simple because there's a second.
So they're all, it's one indictment that has two armed robberies on it.
Oh.
There's another indictment that has one.
Okay, so he does have two indictments, but there's three different scenarios.
And they're all, we have both of the cases, both indictments here. That's one of the ones I need to communicate to him about me getting reassigned.
Okay, to see if that gets him to focus or not. Okay. Tutman, I do see. Is that the gentleman who's in Douglas County now?
No, that's Mr. Connor.
Okay.
I think he was only sent to Douglas because the Douglas County DA communicated to Kelsey Connor that they were going to try it first.
Yeah.
And I don't know what.
They're regretting that decision.
I talked with Ms. McCartney the other day, and she just said, look, there's a bunch of stuff coming your way, but I went to Douglas and visited Mr. Connor maybe about 3 weeks ago. But he was like, yeah, we're going to trial, yada, yada, yada.
In Douglas?
In Douglas.
Okay.
And then the end of the week of the trial, Ms. McCartney checked in to see kind of, did they win, did they lose? And she found out they didn't even try it for really weird reasons.
Okay. Ramel Williams, I mean, that's old, but that's one that seems like handing off is okay.
Yeah, I just got Mr. Williams. I just got the discovery.
Oh, because he fired someone.
Yeah, or the person quit. I'm not sure who.
Whatever it was, but someone rolled off his case because he's the one with the co-defendant. All right. You don't have this Williams. Michael Robinson, you just got back onto it, but it had been someone else before. So that is one that.
Correct.
Okay.
I will say that he and I have a pretty good relationship. He is myself and his mother. His mother has a comfort level with me. Samoa Hilton is handling that case for the state.
Say that again.
Samoa Hilton.
Oh, Ms. Hilton is okay because of the nature of the relationship between the victim and the
That's conversations. I can't say how great I think the offer is going to be, but I do expect there will be an offer that possibly includes a reduction. I'm not sure to what or not, but I would say that has a better chance of resolving than the ones you've named already for me.
Okay. Sherry Grant.
So Ms. Grant actually butted out.
She did.
She butted out like 2 days ago.
Holy smokes.
Yeah. So
okay.
She called me from her cell phone yesterday morning.
Well, I guess good for her. This was a bond that had been set long ago, and you argued to get it reinstated, and it was reinstated. It's a big old number.
Yeah.
Okay. I think that's, I mean, there's some others here, but I'm just thinking of ones where I know you've done some work in court on them, and I think that's the
only
main
one
universe.
that's not on the list that I would anticipate keeping, and it's just again for continuity reasons. Devontae Dean. It's the shooting case at Lennox Mall.
Oh, but you have the one who supposedly was joking around on the train with the guy, but not the one believed to be the shooter.
He's not supposed to be the shooter. I think in the state's narrative, he would be the lookout, is what the accusation is.
Okay. And the shooter is represented by the conflict defender or a private attorney or somehow C3. Okay.
Conflict. Unless he just hired
Mm.
Snyder admin representative.
I'm not aware of that. Okay. All right. Well, I appreciate those updates. How are you, sir?
Good morning, Your Honor. How are you?
I'm well. Somehow, Judge Ellerby's team didn't get word to the jail, so they're getting Mr. Odister right now. When he makes it to courtroom 3, he and Mr. Petty are going to have a few minutes in a breakout room. So Mr. Petty can take the pulse. I got some good background from the judge about how this one's been a little bumpy. But if the offer is still 3 to serve 2, balance probated, Mr. Petty can reconfirm that with his client and we'll see what happens.
All right.
Great. Thank you, Mr. Franklin.
How did it exactly go? Was it dial in or was it?
It's dial in. I mean, you're welcome to come in here. I'll be right here, but it's Zoom.
Okay. All right. Thank you much.
You bet.
Oh, and I was going to ask Mr. Franklin. Mr. Franklin.
Everyone have a nice day.
Thanks, Miss All. You are free to go.
All right. See you guys later.
Patty, how are you?
Is the plea, if it goes through, to both counts?
No, Your Honor.
Count one is null
Count
pros.
one would be null pros as part of the plea, and it would be solely to count two.
As an A and C recidivist.
As an A and C recidivist. That's correct, Your Honor.
Okay.
And I believe in speaking with Mr. Petty, it'd be a stipulation as to him being an A and C recidivist for today's purposes.
Okay.
That's correct, Your Honor.
Thank you. Ms. Rivers, can you hear me?
Yes, Judge, I'm here.
Good morning.
Good morning.
Did you get a call or an email from the court reporter who had been taking down our civil trial?
Yes, I did. I received it this morning.
Have you agreed to help her cover the little bits and pieces that will be occurring today, or what did you?
I did. I spoke with the agency as well as the reporter, and I did agree to go ahead and take down the verdict, today's proceedings.
Super. I appreciate you doing that. I hope that's not awkward or procedurally difficult.
No, what I need is a caption. I don't have any information about the case. I did ask that be emailed to me, but I haven't received it as of yet.
I will email you the verdict form that has the style of the case on it. We have a question from the jury that we'll need to get on the record when I bring the lawyers back in here, but I needed to figure out how that other court reporter had left it, and I guess you agreed. So let me email you the verdict form, and I think that'll give you the basics that you need.
Okay, great. Thank you, Judge.
Sure, thanks for helping.
Are you currently in trial, Your Honor?
I am. We have a jury in Judge Glanville's courtroom.
Yeah, it's gotta be courtroom, right? Sorry.
Me? Aha, look at that. Are you Mr. Odister? Whoops. Pardon me?
I said, yes, sir, I'm Mr. Oddister, but I want to go by my real name, Christopher Oddister.
I'm gonna call you Mr. Oddister. I won't use your first name. Is that okay?
Yes, sir.
I'm Judge McBurney. We haven't met before, and we're not on the record quite yet. I just want to let you know that Judge Ellerby, who has worked with you on this case, indicated that this might be the day when you're prepared to resolve your case. I'm going to move you into a breakout room with your lawyer, Mr. Petty, so that the two of you can talk a little bit, and then you're going to come back and join me and Mr. Trepanier, who's here in court, and we will figure out if you want to go forward with the plea or not, okay?
Yes, sir.
So sit tight for a sec.
Yes, sir.
All right, that is all good. Adam Petty, courtroom 1. All right, you should see on your screen an option to move into a breakout room. Once you're there, you'll be able to speak privately. We'll see you soon.
Your Honor, thank you. Mr. Oddister and I have talked, and he's prepared to go forward this morning.
Great. We will get started in just a second.
Thank you, Judge.
All right, I am back. Are you there, Mr. Oddister?
Sir, yes, sir.
Great, there he is. Mr. Oddister, it is my understanding that you are prepared to enter a negotiated plea to count 2 of your indictment. We're going to make sure we can be on the record. Ms. Rivers, are you ready to go?
Yes, Judge, I'm on the record.
Great. So this is indictment 20 SC 177186. It is a case from Judge Ellerby that I am covering at her request. Mr. Petty is on our Zoom call. He represents Mr. Oddister, and we have Mr. Say your last name for me.
Trepanier.
Mr. Trepanier here representing the state. Mr. Oddister, before we get into the substance of our hearing today, I want to make sure you are comfortable proceeding remotely. You are connected to Mr. Trepanier and I are here in my courtroom. Mr. Petty is connected via Zoom, and you, Mr. Oddister, are in courtroom 1 out at the county jail. Are you willing to proceed remotely in this fashion?
Yes, sir.
If you need to speak with Mr. Petty in confidence, let me know. You've already had an opportunity to do that before we started this hearing, but I'm happy to move you and Mr. Petty back into a breakout room if there's anything that you need to discuss with him in private. Will you let me know if you need to do that?
Yes, sir.
Great. Then in just a moment, Mr. Trepanier is going to put you under oath. Once you're under oath, it's important that you answer his questions and mine truthfully and completely. If you have any questions of your own, please bring them up. I need to be comfortable that you understood everything we're going through. I don't think that's going to be a problem for you, but I do need to know if you've got any questions. All right?
Yes, sir.
Mr. Trepanier, when you're ready.
Yes, Your Honor. Mr. Oddister, will you please raise your right hand as best you can? Do you swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. Please state your name, your age, and your date of birth.
My real name is Christopher Lamar Oddister. My real date of birth is 8/29/1972.
And how old are you?
I'm 48, sir.
And Mr. Oddister, have you also gone by Raymond Oddister?
So yes, sir.
And can you spell your last name? I know on some systems of ours, it's with a B as in boy, and on others, it's with a D as in Delta. How do you spell your last name?
It's Odister.
And that's D as in David.
Yes, sir.
Great.
Yeah, Raymond is an alias, and I want to get that cleared and try to get it on my record. So when I go to prison, I'm going up under my real name.
Okay.
Mr. Oddister, are you now under the influence of any medicine, drugs, or alcohol?
No, sir.
How far did you go in school?
The 11th grade, sir.
Can you read and write English?
Yes, sir.
Have you had the opportunity to review the indictment in this case that charges you?
Yes, sir.
That was loud. Is that like an alarm? Will that be going for a while, or that's a temporary thing? Okay.
Hey, it stopped.
Mr. Oddister, now that alarm has stopped, do you, I'm just going to repeat my last question just to make sure that it was heard, but have you had the opportunity to review the document that charges you in this case, the indictment?
Yes, sir.
Okay. Do you fully understand the nature of the charges that are pending against you?
So, yes, sir.
And that by pleading guilty today, you're giving up the following rights that I'm about to list for you. the right to trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any evidence in your defense, or the right to remain silent, the right to an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand those?
Yes, sir.
And do you understand that you are giving up those by entering a plea today?
Yes, sir.
All right. Do you understand that if you were to plead not guilty or you were to remain silent and enter no plea at all, the state would be required to have a trial on these charges?
Yes, sir.
And today, do you understand that you are pleading guilty to count 2 of the indictment, financial transaction card theft, and as part of this negotiated plea, the state would move to null pros or dismiss count 1, the theft by taking?
Yes, sir.
And do you understand that the minimum and maximum for the financial transaction card theft count is a minimum of 1 with a maximum of 3 years to serve? Do you understand that?
Yes, sir.
Are you currently on probation or parole?
No, sir.
Do you understand that if you were to be on probation or parole, a guilty plea today would almost certainly cause you to be revoked on that probation or parole?
Yes, sir.
And do you understand that the offer, the negotiated plea today would be on count 2, 3 years to serve 2 years, the balance to be probated. Special condition would be to stay away from the Greyhound bus station, as well as no contact with the victim in this case and the witness, Ms. Roberts?
Yes, sir.
And do you understand that you'd also be sentenced as an A and C recidivist?
Yes, sir.
And do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is the 3 years to serve? Do you understand that?
Yes, sir.
And do you understand that should the sentence include a period of probation, you'll be required to obey both the general conditions of probation and any special conditions of probation?
Yes, sir.
And do you understand as general conditions, you'll be required to follow basically the conditions that probation gives you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit?
Yes, sir.
And do you understand the special conditions that the state is requesting in this case would be a stay away from the Greyhound bus station, as well as no contact with the victim and witness in this case?
Yes, sir.
And do you understand that a violation of any of those conditions could lead to a revocation of any period of probation?
Yes, sir.
And are you entering a guilty plea with an understanding of everything we just talked about?
Yes, sir.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, sir.
Are you satisfied with your lawyer, Mr. Petty, and what he's done for you with this case?
Very satisfied.
Do you have any more questions from Mr. Petty before we go on?
No, sir.
Have you understood everything that I've asked you so far today?
Yes, sir.
Understanding all your rights, do you wish to enter a plea to the charge of financial transaction card theft today?
Yes, sir. Guilty.
And is it your decision to plead guilty made freely and voluntarily?
Yes, sir.
And in this case, how do you plead to count 2 of the indictment, financial transaction card theft?
Guilty, sir.
And did you in fact commit the offense to which you are pleading guilty?
Yes, sir.
And are you a United States citizen, Mr. Oddister?
Yes, sir.
And do you understand that if you are not a United States citizen, a guilty plea today would almost certainly lead to your deportation from the country?
Yes, sir.
Do you understand that if you wish to challenge this plea for any legal error, you have one of 2 ways to do it? Your lawyer can explain what those 2 ways are and how they work, but I must advise you of some of the time limits. The first way is a direct appeal, and you have 30 days from the date of the sentence that it's entered to file that appeal. And the second way would be a habeas corpus petition, and and in this case, that would be a period of 4 years to file. Do you understand those time limits?
Yes, sir.
And Your Honor, had this case gone to trial, the state would have proven beyond a reasonable doubt that on May 26th of 2020, officers were dispatched to the Greyhound bus terminal located at 232 Forsyth Street Southwest in Atlanta, Georgia, in Fulton County, in reference to a stolen vehicle call. Officers arrived at the location and made contact with the caller, Miss Davoya Andrews, that's spelled Davoya, Andrews, common spelling. She stated that she parked her vehicle, a 2018 red Dodge Journey, in the parking lot there and walked into the parking kiosk. She states that while she was walking there, an unknown dark-skinned black male with a black baseball cap, approximately 5'6" began to threaten her about booting her vehicle. She states that she ignored this male and continued to walk, going inside the bus station for information on where to pay. She stated that she left the key fob to her vehicle in the bag that was sitting on her front passenger seat. She states that as she came back towards her vehicle, she noticed that the front passenger car door was open and her vehicle was being driven away. Again, the caller indicated that there was a black and red baseball cap on the ground, which she indicated the person that she was speaking to prior to the theft was wearing. Officers sent a lookout for the vehicle over the radio, and ultimately the vehicle was located essentially kind of across the street from the parking deck. Inside the vehicle were 4 male individuals. They were briefly detained. However, ultimately a witness who is at that location, Miss Abigail Roberts, indicated that it was Mr. Raymond Oddister that was engaged in conversation with the driver. And then ultimately when the driver left her vehicle, it was Mr. Oddister that got in the passenger side of the vehicle, slid over to the driver's side of the vehicle, started it up, and drove away from the location. Ms. Roberts positively identified Mr. Oddister, and she identified him as black and knew him from previous dealings in the area. Ultimately, the victim was able to be reunited with her vehicle, and the defendant was arrested near the scene. A search incident to that arrest recovered a stolen debit card belonging to Mr. Michael Beard. That debit card having been stolen previously, Mr. Oddister was arrested and transported to the Fulton County Jail. Prior to that, he was Mirandized and gave a statement, and that statement was consistent with that of the witness who identified him up to the point of whether or not he was the individual who took the vehicle. However, because ultimately he was not recovered in the vehicle, the state believes that pursuant to this negotiated plea, the state will move to dismiss count 1 or move to no pros count 1 and proceed on the second count in this case. A review of Mr. Oddister's criminal history shows 15 prior felony convictions. I know that at some prior hearings with Judge Ellerby, Mr. Oddister did express concerns that some of those did not actually belong to him, that some were actually his brothers, but did indicate ultimately that he was an ANC recidivist. In looking through each of those, even assuming that discounting some of them, they all appear to be mostly theft by receiving or theft by taking stolen property, as well as a drug case, a couple drug cases and a couple burglary cases. Your Honor, those go back from 1991 until 2017. Again, as it relates to the recommendation on this case, the state and defense have reached the joint sentence recommendation of on count 2, 3 years to serve 2 years, the balance to be probated. Special conditions would be to stay away from the incident location, no contact with the complaining victim, and no contact with the identifying witness in this case. Further, the sentence would be pursuant to Mr. Oddister being an ANC recidivist. I believe that will be stipulated to today as well.
Any restitution owed to Mr. Beard?
No, Your Honor. As far as I'm aware, there's no restitution that's owed to Mr. Beard, and there is also, so the state's not going to be seeking any restitution today.
Right. Ms. Crawford, does Mr. Oddister have any open, active, probated cases?
Judge, I show that Mr. Oddister has a 13 case. It's 13 SC 118104 out of Fulton County. That case is a theft by taking, and he has 1 month and 27 days remaining on that case.
13 SC 118104.
Yes, sir.
Okay. That's the only open one that you show.
That's correct.
Got it. Oh, look, you even sent something about that. Okay. Under the name Christopher Oddister, the name he wants to go by now.
I thought those was over with on June 11th. That's why when she asked me to have my probation, I said no, because I got paperwork right here where it say that it's over with June 11th.
Okay. Oh, it's sorry, go ahead.
It's going to end August the 11th. That's why you have 1 month remaining.
Okay. It's close. And this is not going to upset the deal that's been negotiated. I want to try to close out everything that can be closed out, Mr. Oddister, and that's why I asked.
Yes, sir.
Mr. Petty, what do you want to add to what I heard from Mr. Trepanier?
Thank you, Your Honor. We are asking the court just to accept this plea as negotiated between the parties. As you heard from the state, it's pertaining to count 1, which of course has already been motioned for a null pros, but just talking a little bit more about that, that was an incident where Mr. Oddister, of course, is not one of those 4 individuals detained when that vehicle was recovered. None of his DNA or prints or anything like that was ever recovered from that vehicle. None of the individuals who were actually detained at the car said that they had received the vehicle from Mr. Oddister. So we do find, or do believe is appropriate to null pros count 1, certainly in agreement with that. As pertains to count 2, Mr. Oddister is entering this plea of guilty because, as you heard on the record, it was, this financial transaction card was recovered from his person. However, I do know that when the actual card itself was first stolen, it was not Mr. Oddister. He was actually incarcerated in prison at that time. But nonetheless, he did have that card in his pocket and had withheld and obtained that card, knowing that it was not his. So we do believe that going forward on count 2 is appropriate. Mr. Oddister does stipulate to being an A and C recidivist. He does have more than 3 felony convictions on his record. So to that point, we do stipulate. Mr. Oddister is 48, soon to be 49 in a couple of months. He's got a daughter who I believe is 14 years old right now, living in the Gainesville area. Mr. Oddister is ready to put this chapter of his life behind him and to move on in the second half of life and to certainly make some better decisions for himself, first and foremost, but also so he can be a better father and strengthen that relationship that he has with his daughter. So that is his goal. That is why we're entering this plea here today. Mr. Oddister has been in custody continuously on these charges since May 26, 2020. So, of course, we're asking that he be given credit. I believe it's 386 days, if I'm not mistaken, today on towards the 2 years he will be serving in the state's custody. And with that, nothing further, Your Honor.
All right. Thank you, Mr. Petty. That was helpful. Mr. Oddister, when you are released, where will you go to live?
I'll be probably going to Clayton County,
Clayton County. All right. Any reason you'd need to be in the city of Atlanta for housing?
So run that by me again, sir?
I'm wondering, when you're released, is there any reason why? It sounds like you'd have a place to be in Clayton County, so you wouldn't have a need to be in Fulton County for a place to live. Is that correct?
Yes, sir. But I'm not going to say that I'm not going to be staying in Fulton because my latest friend, she's on Section 8 and she's trying to come back to Fulton County. So we trying to get out of Clayton County. That's why we were staying up before I got locked up.
Well, I may be telling you you're not going to Fulton County. That's why I asked. So you have a place to go that is in Clayton County right now, and it may be that the woman you spend time with wants to shift to Fulton. I'm not sure if you could stay with her, but either way, she's got a spot in Clayton right now. Is that correct?
Yes, sir.
Okay. All right. Anything you want to add, Mr. Oddister, to what I heard about?
No, sir. I'm just ready to go and get it over with, sir.
Okay.
Everything sounds good to me. As long as I get my credit for the time I did since I've been locked up, I'm ready to proceed.
Well, Mr. Oddister, I find that there's a factual basis for your plea. You're pleading only to the second count, the financial transaction card theft. And I understand Mr. Petty's observation that You may not have been the person who stole the debit card, but you were certainly the person who had the stolen debit card when you got arrested. I also find that your plea is knowing and voluntary. A knowing plea is a plea where the defendant understands all the things we've been talking about. And you told me you do, but do you have any questions about anything we've talked about?
No, sir.
Okay. A voluntary plea is one where no one's forced you to enter the plea and no one's promised you anything other than the recommendation that I heard about, the 3 to serve 2 credit for time served. Is that a fair statement that no one has forced you to enter this plea?
Yes, sir.
All right, then I'll accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And all that means, Mr. Oddister, is that while you're on probation for 1 year, if you have a technical violation, you and probation will work that out. If you tested positive for something, or maybe you missed an appointment. But if it's something more serious, you get arrested again, that'll come back to Judge Ellerby, and she will work through what to do with your probation. I am sentencing you as a recidivist pursuant to both subsections A and C of that statute based on your criminal history. I will sentence you as negotiated to a term of 3 years to serve 2 years with the balance on probation. You will get credit for all the time you have served since May of last year. While you are on probation, it will be a special condition of your probation that you stay out of the city of Atlanta. So it may be that your significant other wants to get Section 8 housing in Fulton, and she can do that. It cannot be in the city of Atlanta. I just want to keep you away from places like the Greyhound bus station, because that's just going to get you in trouble, and you want to be in different places. If you really want part 2 of your life, sort of age 50 onward, to be different, you will need to make a different set of decisions about how you spend your time. And one way we're going to help enforce that is by having you not be in Atlanta for that 1 year that you're on probation. You can be anywhere you want in Georgia, but not in Atlanta.
Yes, sir.
You'll also need to stay away from Ms. Roberts. That's the person who shared with the police about what she observed, and Ms. Andrews, who was the owner and operator of the vehicle that got taken. I think that covers it. I'll dismiss the first count. And the one other thing, Mr. Petty, if you are willing to waive any due process notice rights that Mr. Oddister would have in connection with the 13 SC case, what I intend to do in light of this new conviction is to revoke the balance of that case and run it concurrently with this sentence. So that revocation will expire many months before Mr. Oddister's sentence in the 20 SC case is complete. Are you willing to move forward in that way, Mr. Petty?
Yes, sir. So wait, thank you.
All right. So 13 SC 118-104, in light of your new conviction, I will revoke the balance of your probation. And that'll be closed out. Ms. Crawford, do you need any information from Mr. Oddister at this time?
No, Judge, I don't need any information.
Okay. Mr. Oddister, any questions?
No, sir.
All right. Anything else from the state?
Nothing further from the state, Your Honor.
All right. Thank you, everyone. And thank you, jail, for getting us Mr. Oddister.
All right, no problem.
Hold on, give me one.
Take care.
All right, thanks, sir. Thank you, Ms. Ben. Y'all later.
Okay, so Boston,
Thank you, Mr. Oddister.
he's a conflict.
Your Honor, I believe that concludes my business. It's been a pleasure. Thank you very much. May I be excused?
Yes, sir. Thanks for your time today.
Thank you very much, Judge.
Ms. Rivers, I will send you an email with a different. Well, I guess you could just stay on this. We'll keep this going for now. We can. Ms. Crawford, you're free to go. Thanks for your time. But I need to get on the record this question from the jurors. So I'll bring the lawyers in for the civil case. I sent you via email the style of the case. So if you are ready to transition in a couple minutes, we'll take down about 2 minutes worth of civil stuff. Is that okay?
Yes, I'm ready, Judge.
Great.
And Your Honor, may I be excused?
Yes, sir. Thank you.
Thank you for accommodating us today. I very much appreciate it.
Happy to do it.
Judge, I have a question.
Yes, ma'am.
On the older forms, it used to be a section that said recidivist, but now it has repeat offender as imposed. Is that the same?
Wow. Repeat offender is a term like that we use because of the Atlanta police. Does it have the statute that 17-10-7 on there?
No. So what I'll do is I'll just make a note and put it.
I would check repeat offender. I wouldn't want them to miss the fact that he needs to serve the time with no parole or anything. So I would check repeat offender, but I would also put 17-10-7A and C all over the place.
Okay. Okay.
Thanks. All right, Ms. Rivers, I'll be right back.
I'm gonna stay on this Rivers because I want to hear what's going on in the civil.
Okay.